I call this meeting to order. So welcome to meeting number 112 of the House of Commons Standing Committee on Public Safety and National Security. Pursuant to the order of reference referred to the committee on Wednesday, May 29th, 2024, and the motion adopted by the committee on Monday, May 27th, 2024, the committee resumes its study of Bill C-70, an act respecting countering foreign interference. Before we begin, I would like to ask all members and other in-person participants to consult the cards on the table for guidelines to prevent audio feedback incidents. Please take note of the following preventative measures in place to protect the health and safety of all participants, including and particularly the interpreters. Only use a black approved earpiece. The former gray earpieces must no longer be used. Keep your earpiece away from the microphone at all times, from all microphones at all times. When you're not using your earpiece, place it face down on the sticker placed on the table for this purpose. Thank you all for your cooperation. Today's meeting is taking place in a hybrid format. I would like to make a few comments for the benefit of members and witnesses. Please wait until I recognize you by name before speaking. A reminder that all comments should be addressed through the chair. And specific comments on C-70. I'd like to remind members that amendments to Bill C-70 must be submitted to the clerk of the committee by 4 p.m. Eastern Standard Time, Friday, June 7th, 2024. It is important for members to note that pursuant to the order adopted by the House on May 30th, the 4 p.m. deadline to submit amendments is firm. This means that any amendments submitted to the clerk after the deadline and any amendments moved from the floor during clause-by-clause consideration of the bill will not be considered by the committee. I'd also note that to all members of the committee that the charter statement on C-70 has been distributed and you should find it in your inboxes. So I'd like now to welcome our witnesses for today. Monsieur Villemure, on point of order.
Oui, j'aimerais m'assurer que les...
Thank you. I'd just like to make sure that all sound tests were done for the purpose of the interpreters, including those who are appearing remotely.
All come tests.
Merci beaucoup.
Merci.
Thank you very much.
So I'd like now to welcome our witnesses for today. So with us as an individual, we have Mr. Richard B. Fadden. Welcome back. I remember having you here before. Canada-Hong Kong link, we have Gloria Fung, immediate past president. And by video conference for Hong Kong Watch, we have Catherine Leung, policy advisor. So I'd like to thank you all for your participation in our meeting today and your flexibility to appear so quickly. I now invite Mr. Fadden, Mr. Fadden to make an opening statement of up to 5 minutes. Please go ahead, sir.
Thank you, Chair. Thank you for the opportunity to speak to you on Bill C-70. I'm especially grateful for this opportunity because it addresses a number of issues I and many others have advocated for some time. C-70 is a relatively complex and in some cases quite technical piece of legislation, but its overarching thrust goes a considerable distance towards dealing with the threat of foreign interference, again, a threat which has been with us for some time. In particular, the creation of offenses relating to foreign interference and the creation of the Foreign Interference Transparency Commissioner and of the registry he or she will be required to maintain will provide tools which Canada will be lacking. These measures will not make foreign interference go away, but they will help deal with the threat. As well, the provisions amending the CSIS Act permitting the service to disclose information much more broadly than is currently the case will assist government institutions, but also the private sector and civil society to understand and deal with threats to our national security. In this respect, these amendments will help deal not only with FI, but with other threats to the national security. Two last comments. The first deals with concerns that I've seen reported in the media to the effect that some provisions in the bill risk charter compliance issues. I'm not a charter lawyer. Indeed, I'm a lapsed lawyer, but I do not see this risk in the actual words of the bill. Is there a possibility that its implementation might increase the risk? Possibly. Having said this, it seems to me that this is frequently the case with any law which creates offenses. But I do not believe, and I hope you will agree with me, that such concerns should prevent you from approving C-70. I think there are 4 reasons for this. First is the certificate of the Minister of Justice, which the Chair has just referenced. I think also Parliament is entitled to believe that in the good faith implementation of the law by ministers and officials. If there's a real problem, there's always recourse to the courts. And finally, if there are really serious problems, you can change the law. My last comment relates to what I understand are the view of some that C-70 should not be dealt with on a fast track. I would suggest to the contrary, that the expeditious review and passage of C-70 is in the national interest. I can see no possibility that our geopolitical adversaries will in any way in the foreseeable future modify their behavior so as to lessen threats to our national security. These threats are real and affect virtually every part of our country, private sector, civil society, individuals, and governments at all levels. NSCOP, NSRIA, and the Hague Inquiry all clearly support the view that the threats you are considering are real and require action. To not deal with C-70 in the days and weeks ahead, and if you'll forgive me for saying so, in an environment increasingly affected by the possibility of an election, could mean the demise of C-70. Last thought, even if C-70 received the royal assent next week, implementation will take some time. And I hope you will take this into account as you consider timeframes relating to the bill. Thank you for your attention, and in due course, I'd be more than happy to try and answer your questions. Thank you, Chair.
Thank you, sir. I now invite Ms. Fung to make an opening statement of up to 5 minutes. Please go ahead.
Mr. Chair and distinguished members of the committee, I thank you for this opportunity to comment on Bill C-70, the Countering Foreign Interference Act. I'm the immediate past president of Canada-Hong Kong Link and convener of the Canadian Coalition for a Foreign Influence Transparency Registry. The coalition established in 2021 consists of 33 multicultural community organizations, think tanks, and human rights groups across Canada. Our mission is to advocate for a foreign influence registry to be enacted in Canada to enhance transparency in the democratic processes. Over the past 2 decades, both citizens and Canadian civil society have repeatedly warned our governments about foreign interference and transparency repression in Canada, but they have remained complacent. The transnational repression faced by diaspora communities includes telephone threats, cyberbullying, and smearing of Canadians through disinformation campaigns, surveillance, coercion, harassment through counter-protests, and physical attacks. The Chinese Communist Party is by far the most active state player in this interference operation through its sophisticated network involving hundreds of proxies, posing a major threat to our national security, sovereignty, and democracy. Canada is at the back door to U.S. China's adversary. By infiltrating Canada, China can access sensitive intelligence information of the U.S., the Five Eyes allies, and NATO. CCP agents capitalize on the openness of our democratic system, infiltrating into community, media, academic, and business sectors. They are active in undermining our democratic institutions at all levels of government. As we recently brought altogether 8 MPs from all 5 federal parties to call for the immediate introduction of the legislation to counter foreign interference. Our coalition welcomes the bill and strongly supports the emerging nonpartisan consensus to get the registry passed, to get it up and running before the 2025 election call. We hope the House can send it to the Senate before it rises for the summer. I would like to make the following recommendations. Number 1, the government should set up an independent commission to coordinate and monitor the implementation and future periodic reviews of the Act. Number 2, the Act and corresponding regulations should be reviewed and updated within 1 to 2 years after the 2025 federal election. But after this, they can be reviewed once every 5 years in accordance with the rapidly evolving foreign threats. Number 3, for the purpose of the registry, political activity defined in the Act needs to be expanded to include elections to internal political party offices, political party leadership contests, appointments of individuals to public offices, government hiring decisions, third-party political advertising, decision-making within parliamentary and legislative caucuses, such as the selection of officers, expulsion of members, and removal of leaders, law enforcement decisions, and decisions of tribunals and regulators. Number 4, legislation should allow authorities to be proactive in implementing the registry. In Australia, for instance, authorities can send a request for information to determine if individuals or entities need to register or not. Thank you.
Right on the dot. Thank you very much. We go now to Ms. Leung to make an opening statement of up to 5 minutes. Please go ahead.
Thank you, Mr. Chair. I'm the Policy Advisor for Hong Kong Watch in Canada, and I am before the committee today to speak to Bill C-70. Hong Kong Watch supports the speedy passage of the Countering Foreign Interference Act, such that it is in place before the next election. We support the bill as a whole, but I will use my time to speak with emphasis on suggested amendments that would ensure the scope of the bill thoroughly addresses foreign interference. We support the proposed amendments to the Canadian Security Intelligence Service Act, especially amendments related to equipping national security partners to build resiliency to threats by enabling broader disclosure of CSIS information to key partners beyond the Government of Canada. Foreign interference is not limited to governmental targets, but rather affects individuals and organizations across various sectors. We know from media reports and previous committee testimony that there are considerable foreign interference activities targeting Canadian universities, businesses, and technology. This is why broadened information disclosure will allow institutions to better understand and anticipate potential threats and take proactive measures to safeguard their operations and intellectual property. We're also supportive of the proposed measures to counter foreign interference under Part 2 of the bill. The creation of new offenses for foreign interference, including deceptive acts that undermine democratic processes and harm Canadian interests, is much needed. These amendments address the reality that foreign interference often targets individuals at the grassroots level, thereby indirectly influencing democratic processes and Canadian interests. While intimidation, threats, and violence are tactics used by foreign entities to silence dissent within diaspora communities, discrimination is another method employed to suppress opposition. We have seen cases where individuals in Canada have faced job loss or eviction from their homes due to their political opinions. We would be supportive of proposed amendments that acknowledge the tactic of discrimination and provide mechanisms to counter it effectively. We also support the creation of the Foreign Influence Transparency Registry by imposing obligations on individuals and entities to register arrangements and disclose foreign influence activities. The Government of Canada can increase transparency and accountability. However, it is important to expand the scope of the Act beyond political processes. Much of foreign interference occurs at the community level, where it can suppress public discourse and indirectly influence democratic processes. Let me illustrate how transnational repression as a form of foreign interference can have an impact on political processes through case studies of Hong Kongers in Canada that I have heard through my work at Hong Kong Watch. A pro-democracy activist from Hong Kong fled to Canada in 2020 after participating in the 2019 protests and encountering police altercations that led to the detention of her friends. She claimed asylum, settled in Calgary, and continued her advocacy for democracy in Hong Kong. She's one of the founding members of a group of volunteers that assists persecuted Hong Kongers seeking asylum in Canada. Since publicly criticizing the Chinese government, she has received anonymous threats on Telegram, including harassing messages about her appearance and advocacy, and graphic videos, including a bloody video of a woman suffering severe blunt force trauma to the head and a video of a beheading, with captions referencing her involvement in pro-democracy organizations. The sender also disclosed personal details about her life, including her boyfriend's name, her employer, and her workplace address. She has reported these threats to CSIS and the RCMP. As Bill C-70 is written, the anonymous sender in this case would not trigger a requirement to register as a foreign agent, as this is not an activity directly related to parliamentary or legislative proceedings, development of a legislative proposal, development or amendment of a policy or program, decision-making by a public office holder or government body, elections, referendums, or nomination contests. Rather, this is something that has silenced this individual. Due to fears for her safety, she no longer participates in pro-democracy advocacy for Hong Kong, despite permanently living in Canada. Foreign states use transnational repression to discourage dissent from diaspora communities, thereby undermining democratic participation and the ability of elected officials to represent their constituents fully. Expanding the Act to encompass all levels of foreign interference activities, including transnational repression and intimidation, will provide a more comprehensive safeguard against these threats. With that, I conclude my remarks here.
Thank you for your remarks, and thank you all. We will start our questioning at this point. We will start with Mr. Caputo. Mr. Caputo, go ahead, 6 minutes.
Great. Thank you very much, Chair, and I thank all the witnesses. We've had some wonderful witnesses here today. We have wonderful witnesses here today, but we've had excellent witnesses throughout. But this panel in particular really stands out to me. So Ms. Leung, Ms. Young, or Ms. Fung, and Mr. Fadden, thank you for being here. I only have 6 minutes, but there's really so much to ask. Mr. Fadden, I'm going to key in on the first note that I took from what you said. You said this threat has been with us for some time. Now, we've heard from different people, but you have a fairly distinguished background in this regard. How long has this issue been with us, and is it intensifying, or are we just more likely to discover it right now?
Chairman, I think it's difficult to, pick a particular day or week or month, but I would say that easily it has been with us in a noticeable way in the last couple of years of Mr. Harper's government. It existed before then, but I think that with the passage of time, it's intensified and it continues to intensify. I think the most noticeable increase in intensity occurred after President Xi became the leader of China. His activity is much more aggressive and proactive, and that's been manifested in all of the policies of the People's Republic, both with respect to foreign interference and more generally.
All right. Now, obviously, we take, this act is country agnostic so far. But have you noticed any other, the intensity from any other foreign state actors?
I think that, Mr. Chairman, China stands out. But I also think, as has been reported in the media, Iran is becoming slightly more active. I think India as well. And not just, the killing of Mr. Najjar, but throughout the community. And Russia operates, I think, in a slightly different way. They intervene. If China sort of covers the waterfront as much as they can, Russia tends to be more specific. They're more like a surgeon. And they do intervene. I don't think it's necessarily increased in intensity a great deal, but they're there and they continue to do so. Not necessarily through their diaspora, though. That's the one big difference between them and China.
I see what you're saying. So you've commented that there's been a fairly recent difference in intensity when it comes to foreign interference. Is that solely on foreign state actors having a greater desire to interfere, or is there something that's happening here in Canada, or a lack of enforcement perhaps, that is playing into that, if that makes sense?
I think it's a bit of both. I think, as I said a minute ago, China in particular, but also others, have become much, much more aggressive and assertive. But I also think that compared to our close allies, Canada has been a little bit slower in providing the state with tools to deal with this. I'm not suggesting that it's been ignored, but I am suggesting it's taken us a while to get there. The United States, the United Kingdom, and Australia have dealt with this issue, I think, faster than we have. Your colleagues in Australia, for example, have enacted a variety of pieces of legislation directly to address both foreign interference and espionage. So I think the main difference is when an adversary goes through a list of countries that it wants to attack, it will pick every country and do something in all of them. But if there's one that is slightly less organized, slightly less structured to push back, they'll make a bit of an effort there.
Okay, thank you. Now, Ms. Leung, you talked about, I wrote a quote here, interference targets individuals at the grassroots level. And you talked about even job losses and evictions, something that perhaps people in this room might not be used to hearing about. When we think of interference, we think of well, certainly I think of different things than that. Can you expand a little bit on that? Because you talked about the silencing of individuals as opposed to impacting government. We have about a minute and a half. Are you prepared to expand on that for that time, please?
Yeah, I can give a case study for both of these cases. So the job loss one was a community member from the Hong Kong diaspora here in Canada who told me that he was employed by someone of Chinese descent here in Canada, and that person had very strong feelings about the Hong Kong pro-democracy movement. Now, it's notable that he came to Canada under the Hong Kong pathway after having participated in the pro-democracy movement, and his employer told him that it is not because of your political opinions that I treat you this way. And shortly after that, he was mistreated to the point where he left his position. The other case is a young woman who was renting a shared house in Toronto. She participated in a pro-democracy protest in 2019 in Canada, brought home posters, flyers from the protest, and then put them up in her room, which is her space. Her landlord then evicted her. And it was shortly after that that she found out that this landlord was, quote, a core member of the United Front in Canada. So that is a bit of context as to what that means.
Thank you. I see I only have 15 seconds, so I will pass the baton at this point, Mr. Chair. Thank you.
Thank you, Mr. Caputo. We go now to Mr. Biddle for 6 minutes. Please go ahead, sir.
Thank you very much, Mr. Chair. I guess I'll start my questions to Mr. Fadden. I appreciate a fellow lapsed lawyer. There's a few of them at the table, around the table on both sides of them. I was wondering if you could talk a bit about how this legislation, balance providing CSIS with modernized authorities while still ensuring transparency, oversight, and independent review?
Well, I think principally, Mr. Chairman, the bill maintains quite a heavy involvement of the federal court in anything that's being proposed. Not to be trite, but a friend of mine was reading the bill and they said it seemed like an employment opportunity for the federal court. I mean, the federal court is mentioned a lot in this bill. If any of you were going to ask me if I thought that anything could be done to the bill to improve it, I would say to simplify it a bit, but I understand that there's a whole bunch of checks and balances written into it. But fundamentally, I think that the requirement for CSIS to obtain ministerial authority for the use of data sets and a whole variety of other things, both from the minister and then going to the court, will ensure that they stay squarely within the law. I think that the authority being given to CSIS to speak more broadly with civil society and the private sector will simply make these issues more understandable to everybody and will help an understanding of what these issues are. One of the things that struck me since I've left government is how little people understand about these issues. So CSIS going out there and talking to the private sector and civil society and getting feedback in the other direction, I think, broadly speaking, will simply contribute to an environment where greater transparency and accountability will be easier. I'm not suggesting by this that, all of a sudden everybody will be cleared to the top secret level and, it'll all go away. But to my mind, there's a pretty careful balancing in the Act. Again, if I had my druthers, I'd simplify it a little bit, but I do understand the checks and balances that are built into it.
No, I appreciate simplicity. Despite being a lawyer and the excitement of a make-work project for lawyers, simplicity is generally the best way to go. With the changes in proposed in C70, how, in your mind, does this compare us with our Five Eyes allies, especially the U.S.?
I think it brings us very, very close to where they are. I think we have to be careful not to compare directly. Our societies are different and whatnot. Most of our allies have had a registry for some time. Some are country-specific, some are neutral, as Mr. Caputo suggested. I think the creation of foreign interference as a crime goes a long ways to bringing us in line with our close allies. So I think if it doesn't put us at the forefront, I think it goes a considerable distance to. Well, to be honest, I think it will lessen the concerns of some of our allies about the caution with which we've approached some of these measures.
You see this legislation having borrowed from other allies of ours?
Yeah, no, I think so. I think Australia is often drawn upon because it's very similar. Also, the United Kingdom. The U.S., it's a bit harder because their system of government, as you know, is different. But in respect to the United States, I think the main thing that this will accomplish is that it will suggest to them quite forcefully that Parliament is taking this very seriously. Simply the creation of crimes, potential penalties of up to life imprisonment is a pretty powerful message that the country is annoyed. But I do think it's mostly the UK and Australia, with the United States likely being pleased that we're going down this path.
Thank you so much. If I can turn to Ms. Fung for a moment. You've been a strong advocate for the creation of a Foreign Influence Transparency and Accountability Act. Can you inform the committee of your advocacy work and consultations you may have had with public safety and your views of the bill we have in front of us with respect to that?
Mm-hmm. Yeah. Well, I have, I have been involved in Hong Kong, and then ever since I have immigrated to Canada, actually I have been observing, monitoring, and also collecting data with respect to foreign interference and transnational repression for the last 3 decades. And I have been serving different NGOs and also coalitions and helping all civil society organizations to come to a common understanding about the magnitude and depth of, the foreign interference, especially the transnational repression, which significantly impact on the safety and also the freedom of expression of Canadians on Canadian soil. And yeah.
How much time do I have, Mr. Chair?
30 seconds.
30 seconds. I thank you. Just say thank you, everyone, to our witnesses, and I'll just pass it along. Thank you.
Merci. On y va maintenant.
Thank you. Then we will now move on to Mr. Villemur. You have 6 minutes. Thank you very much, Chair, and I'd like to thank all our witnesses, Ms. Leung, Ms. Fung, and Mr. Fadden. And Mr. Fadden, I'll begin with you. You raised several points regarding the bill earlier on, and I'd like to know in a few words how it could be improved. Well, that's a good question. I've thought about it considerably, and I think ultimately, given where we are today, I would say there isn't actually much more that I would do, as I suggested to your colleague. I think there could be some improvements regarding the federal court, but this is a good bill. It's not perfect, and I'm sure that in about 5 years you'll see that there are some things that need to be improved. But compared to our allies, it's not bad. Thank you. I did have a few questions about the independence of the commissioner. Now, from reading the bill, it's clear that that individual will be independent in their actions. However, I do have some reservations regarding their accountability and the Department of Public Safety. I would like there to be true independence, that person would be appointed after consulting parliamentarians, both houses. And I'd like to know what you think about that independence. Well, I think that independence is very important. And I think that creating a position like another officer of parliament is good. It's not the end of the world. However, if the commissioner is maintained as described in the bill, I would say that after 18 months or 2 years to ask that commissioner whether things are running smoothly. And the easiest thing is to create an independent position. You know, what we want is trust and accountability. And I'm not necessarily biased against anyone, but I think it would be better for there to be a perception of independence besides it being truly independent. Now, so foreign agents will have to be registered. I'd like to know what you think about this double registration. So if you have a public office holder and you have a foreign actor, I'd like to know what that would involve. So there would be, you know, if a public officer is registered and the foreign actor isn't, then there's a discrepancy. Well, I haven't thought about this. I think there would be advantages to having this double registration because, once again, it would be more transparency. On the other hand, I think we'd have to look at the unintended consequences of this. So I'd have to think about this. Chair, I would encourage you to ask your analysts to look into this. What would the potential consequences be? So you're talking about unintended consequences, and also it could become involve more bureaucracy, couldn't it? But it could inspire more trust. Now, I have another question I have another question about this cooling off period. Let's say before someone works for a foreign government. Well, I agree with that. When I retired, I couldn't speak to anyone at all for 12 months. So I think a cooling off period regarding potential activities with a foreign state is not a bad thing at all. As a matter of fact, I think it would be a good thing. Thank you, Ms. Fung. There is interpretation. There is interpretation.
Oh, how? Sorry.
Vous avez arrêté mon temps, Monsieur le Président.
Chair, I assume you're stopping my time? Yes, absolutely.
An extra 5 minutes, right? Well, can't blame me for trying. Merci.
Thank you. Interpretation, Ms. Fung, you are a lawyer and were involved in the idea of a registry. I'd like to know if you're satisfied with the registry as described in the bill.
First of all, I'm not a lawyer, but we have been working with a lot of lawyers with respect to the Act. To all our coalition member organizations, we consider Bill C-70 to be a good and strong bill. Yeah.
Merci. Madame Long, la même question.
Thank you. I have the same question for Ms. Long.
Also not a lawyer, but I'm happy with the bill as it stands currently. There are amendments that I would suggest, but the bill currently as it stands, I think, is better than what we have in our Canadian framework, and it is a good first step for this government to take to counter foreign interference.
Merci beaucoup.
Thank you very much. Mr. Fadden, I have a question for you. You were talking about Australia earlier on. Now, Australia was one of the first countries to create a registry. However, there haven't been very many prosecutions. So are there technical issues with it? Yes, I believe that's the case. I'm not familiar in any great detail with it, but the intention of the Australian authorities was to provide an additional tool to assist the process. So it wasn't, the idea wasn't to have a huge number of prosecutions. If I understand correctly, there were 2 or 3 other bills that also involved listing various offences. But the idea of the registry was to provide Australian authorities with greater knowledge about who the actors are, but not necessarily give them policing powers. So basically some mapping, yes. So if you look at the registry as proposed here, do you think it's better than Australia's registry? I think ultimately that will depend how it's used, how it's implemented. Do you know, oftentimes something is legislated by Parliament, and then you have to see how it is used. So if the government chooses to have an active, involved commissioner who's going to make a difference, well, I think it could be better than Australia. And it could be a huge contribution. Thank you very much. Ms. Fung?
However, because of the rapid evolving foreign influence patterns, it is of utmost importance for our, for a government and also the future commission to conduct periodic review of the Act and all corresponding regulations on a regular basis. And what I propose is that because this time we are really competing with time, we would like to see the bill to be passed and enacted before the next election is called to protect our national security and democracy. So what I suggest is that maybe we can consider reviewing and updating the Act and corresponding regulations 1 to 2 years after the 2025 election. And then after that, we can review the Act and regulations once every 5 years. The rationale for this is because usually during federal election, there will be a very good, exemplification of the pattern, strategy, and tactics of foreign interference. So based upon what we are going to observe in the next election, that will give us more data to consider how to improve the Act.
Thank you. Merci, monsieur.
Thank you.
Mr. McGregor, 6 minutes, please.
Thank you very much, Mr. Chair, and I'd like to echo my colleagues in thanking all of the witnesses for being here today to help us through this study. I don't think you're going to find anyone around this committee table who doesn't understand the importance of the issue that's before us. And I think that's why with respect to Bill C-70, it is quite rare to see that moment of unanimous consent to get a bill through committee this quickly. That being said, that puts a lot of pressure on us committee members because it is a fairly large and consequential bill, and we need to do our thorough review of it because it still has to go through the Senate. And of course, if the Senate finds that we didn't do our job properly, they'll amend it and send it back to us, adding to further delays. So we want to make sure that we're doing our job properly here. Mr. Fadden, I'd like to start with you. I take note of your comment that putting in a registry is not going to stop the clandestine nature of so much foreign interference. But of course, we do have very consequential amendments to the Security of Information Act, otherwise known as SOIA. However, putting a law in place is one thing, but making sure that we use that law to prosecute and then to convict is another. And I know there's often quite a wide gulf between what is considered intelligence and what is considered evidence, what would stand up in a court of law. What we haven't talked about a lot is that there's some pretty consequential amendments to the Canada Evidence Act to set up a framework to safeguard sensitive information. I know CSIS has to, by the very nature of its raison d'etre, has to be quite careful with the intelligence it has, because you don't want to get rid of an intelligence source. But at the same time, in addition to its detection and disruption activities, I think there's interest that we also want to see some some prosecutions and convictions happen. As you look through this bill, are you satisfied that we have the legislative changes in place through this bill that can lead us down that path?
Thank you, Chairman. I think two sort of related answers. I think the authority of the commissioner to fine people, the standard of proof there will be less than that of the criminal law, and I think it will make it easier for the commissioner to impose fines than would be the case if you're accusing somebody under the Criminal Code or the Evidence Act. So I think on that side, it's a good call. There's still the possibility of judicial review, but the commissioner can simply impose the fines at a reasonable level of proof. I think the other crimes, some of which provide for life imprisonment, which is, to be honest, one of the things that surprised me about the bill, you still have the criminal law level of proof. And I don't know if there's a great deal that can be done without dealing with the old intelligence to evidence issue when you're dealing with the criminal law. I think it's an issue that we've tried to resolve for the last 20 years. Having said that, I think the appointment of special counsel and all these other measures will help. But I think part of the difficulty is that the rules of discovery in this country are amongst the broadest in the Commonwealth. So when we have issues before the criminal or the civil courts, everything becomes available. I'm not sure this is the statute to fix that, but I would urge upon you the view that it is a significant issue. And a lot of people have tried to resolve it. So as long as you have the criminal level of proof, I think you've done what you can. But again, I would urge you to look at this more generally in the future.
Thank you for that. Ms. Fung, I'd like to turn to you. I want to go back to your opening statement where you had some recommendations for amendments. And I just took note of how you were looking at the existing definition in Part 4 of a political or governmental process. And, you note that it covers, I think, six items there. But you wanted it expanded to, I think, include leadership processes, nomination contests, third-party advertising. Could you just walk me through that request in a little bit more detail just to help us understand?
The reason why we would like to advocate for an expansion of the definition is because based on our observation on the ground, foreign interference actually occurs at every single levels of, decision-making process, whether it's within the party or maybe outside the party. And say, for instance, in terms of political party, contests, we have also witnessed a lot of interference behind the scene. And of course, many of the proxies or advocates representing foreign countries, they disguise themselves as being Canadian politician or Canadian community representatives. And even in terms of, some of the other appointments, we have also seen a lot of unlawful lobbying behind the scene, which involves monetary, benefits. Sometimes it could be intangible or in kind. So I think I would like to provide a more broadened understanding of where foreign interference could occur. It's really beyond the imagination of most Canadians. But for people like us who have been observing on the ground, we have seen a lot more than what is being reported by Canadian media.
Thank you, Mr. McGregor. That brings our first round to a close. We'll start our second round. We will end on this round with Mr. McGregor once again. So we go now to Mr. Motz, please, 5 minutes.
Thank you very much, Chair. And as indicated, thank you to the witnesses for being here today. I want to start with you, Mr. Fadden. June 2010. That ring a bell for you? That's when you first started ringing the alarm bells for this country on foreign interference, and that we need to start taking notice. Do you feel somewhat vindicated?
I guess so. although my intention at the time wasn't to generate quite the excitement that it did. But, you know, part of the complication at the time was we were very restricted in what we could say publicly.
Right.
And I just wanted to say that I was very careful to say that foreign influence provided some measure of influence. I wasn't arguing that, you know, everybody was
Right.
controlled, but yes.
So you make a statement that you're somewhat confined into what you could say. Do you think now that the provisions in this act allow give CSIS the powers they need?
I think so. I think.
Is there something more that should be added?
Well, I think the challenge here is going to be for the CSIS or whomever to set up a process because, you know, to pick an example, because one of your next witnesses is from the Business Council of Canada, I think CSIS is going to want to have a relationship with the Business Council where they can share classified information. What does that mean in practice? Are they going to have to security clear them? Or are they going to have a parallel system? So a lot of it, I think, will be in its implementation. The Act itself, I think, provides a legislative framework that is pretty good.
So you have indicated, or not you, but concerns have been raised about the new commissioner, and they're appointed by order in council and without any parliamentary approval, according to the Act. Now, we've heard from some witnesses who have some concerns about that. They figure that the commissioner should be independent and have a similar role to the Auditor General, for example. What's your thoughts on that?
Well, Mr. Chairman, I think I'll repeat what I said to Mr. Villemure. I think the proof will be in the pudding. You could have the current appointment process go forward and there will be no problems at all. So I think the real issue is perception. I think we have a tradition in this country of having institutions like that commissioner be agents of parliament. You know, privacy, access to information, I could go on. To my mind, since we're dealing with an act that wants to promote accountability and transparency and independence, there would be an advantage to making this individual an agent of parliament in much the same mode as the Auditor General.
Great, thank you for that. Mr. Caputo mentioned something about the country agnostic approach to the foreign registry. Can you discuss whether you agree or disagree with that approach?
I think I agree because if you don't have the country neutral approach, you're either going to have to list the countries in the statute or provide the governor and council with the capability of doing that. Also, if you list them, you're going to, without a shadow of a doubt, significantly affect our relations with these countries. I have a lot of problems with China, but China's there. We have to find a way of dealing with it. So I think the neutral approach is much, much better. Doesn't prevent anybody anywhere from dealing with the issue. But listing specific countries, I think, you know, I'm not the foreign minister, but I think the foreign minister would tell you it's not necessary to obtain the objectives of the statute, so don't do it.
Mr. Luong, I have a question about the foreign registry for you. You had indicated previously that the foreign agents registry must encompass activities outside of political or governmental processes. Do you think that, you know, as it stands, it's good enough the way it is, or do you have some recommendations for us that can be added to improve that aspect of your concern?
Thank you for the question. My view is that this bill is good as it stands, but amendments can be made to make it better. It is better than what we have currently in our Canadian framework, but much of foreign interference happens at the grassroots level, as I indicated in my opening remarks. So say, for example, if somebody that is advocating for pro-democracy movements in Hong Kong is intimidated, and to the point where they don't feel safe to do that anymore. They no longer write to their MP. They no longer go for meetings in Parliament. What that does for the movement is that it stops that individual from participating in Canadian democracy with their charter protected rights. This is something that
Let me ask you a question related to that to some degree. So I asked Mr. Fadden about CSIS's powers to share information, and we agree. I think that that's necessary. Do you think the Act goes far enough for the diaspora community in Canada to receive the information they need to protect yourself against foreign influence?
I think that will depend on how the Act is executed. I still have a lot of questions regarding what kind of information will be shared, to whom, and whether that will be sufficient for community groups to counter foreign interference. I think a lot of the problem with foreign interference at the community level is not that we don't know it's happening. We're very aware of it. A lot of our community members experience it, people at my organization included. I think the information sharing is great. We should know what we're facing and become proactive against it. But at the end of the day, it is our safety that we hope that this act can protect.
Thank you.
Thank you, Mr. Motz. We go now to Ms. O'Connell. Please, 5 minutes.
Thank you, Chair. Thank you to all the witnesses for being here. I'll start with you, Ms. Fung. You mentioned areas that the bill should be expanded to include things like election financing, the issues around nominations in leadership races. I guess I want to, because it's my understanding that this legislation does include around the nomination of a political candidate, holding of an election or referendum, decision making by public office holder, and proceedings of a legislative body. So my interpretation, and certainly I think some of the areas we're hearing, is that it would be inclusive of that. And so if there's language that you think is not making that clear, I'm curious how we could improve that. And when it comes to financing of campaigns, even as you mentioned an example of in kind, that would currently be illegal under the Elections Act, and not like if it's not reported. And so that we wouldn't duplicate all of the election financing rules within this law. So how can we ensure that the language is clear, that I'm of this assumption that, for example, a leadership race would be included? Where is the language missing for that causing that disconnect?
I think in order for the Act and regulations to be successfully implemented and also achieving its original purpose, it is of utmost importance that the Act should be, wide, should contain, good definition of foreign interference in various aspects, so that the general public as well as enforcement department, they can base upon which to hold foreign agents accountable. And at the same time, I think public education is also very important, because when I look at the reason why Canada has become almost one of the most badly infiltrated countries by CCP, among all, is because there's hardly any meaningful, sharing of information of CSIS, right? Or maybe RCMP, as how general public, general Canadians can protect themselves when certain circumstances happen to them, and how they can report this effectively in a timely manner to the concerned department, so that the enforcement department can follow up on them. So it really takes two-way communication in order to get this act and regulations effectively implemented.
Thank you. Sorry, I just limited time and I'm trying to get questions to all of the witnesses. Mr. Fadden, you spoke earlier about the speed at which you hope that we move on this and the improvements, and no piece of legislation is perfect, and I acknowledge that. But there's also the suggestion about the independence of the commissioner and having it as a standalone, separate body. In your experience, that in itself would take time, additional time to have that body set up. Frankly, the space, the infrastructure that would be needed in such a sensitive role. Not to say that in the future that might not be the route of Parliament, but do you see that concern around speed of which to set up an independent body commissioner would cause challenges versus being able to use some of the infrastructure that public safety might already be able to build in and support.
No, I think it will complicate things slightly, Madam Chairman or Mr. Chairman. Having said that, if you treat the new commissioner as an agent of Parliament, what I think the Privy Council office usually does is treat them like a commission of inquiry initially, and they sort of develop a structure around them. As I said to your colleagues, I think it would be desirable, but I don't think it's necessary. But if you find out, or if the commissioner finds after 18 months or 2 years that it's not working, I would very much hope that you would be willing to consider changes.
Thank you. And Ms. Lung, if I have a little bit of time, I wanted to speak to you about the horrific example you provided to the committee about the individual who was targeted, her place of business, her address, her boyfriend being communicated with. I can see up to this point there is no criminal offense to deal with that type of intimidation. However, through part of this legislation, although it wouldn't require registration on if it wasn't a specifically deemed political activity, but there would now be new criminal offenses that might possibly be able to deal with that situation. I recognize you've acknowledged more can be done, but does that help alleviate some of the issues that this isn't simply a registry, but there's also criminal offenses as well?
Thank you for the question. Yes, I agree that it is alleviating to the community to know that there are now criminal provisions for some of these acts of foreign interference that occur to them. I would like to point out, however, that discrimination is not part of what is in the bill. And as the examples I've raised earlier, it is a tactic used by the Chinese Communist Party and its proxies to target Canadians who are speaking out against their human rights violations. And that would be an important amendment to add.
Thank you, Ms. O'Connell. On y va maintenant.
We'll now move to Mr. Villemure. 2.5 minutes. Thank you very much, Chair. Mr. Fadden. There will be an amendment to the CSIS Act, and that will allow the services to share information with universities, municipalities, etc. In the registry, however, you don't see these entities listed. Do you think that, say, researchers, universities, even crown corporations, do you think they should also be subject to the registry? Chair? Yes, absolutely. Well, that was quite clear. It couldn't have been clearer. Ms. Lung, I'm going to ask you the same question. So you were speaking about universities in your opening remarks. Do you think that universities, crown corporations, or municipalities should also be on the registry?
Yes, they should.
Well, these are very clear answers I'm getting today. Mr. Fadden. Foreign interference actually hasn't been defined in the bill. How would you define it? Well, there's probably a good reason why there isn't a definition. It's because it's very difficult to define. I would say, though, that it is the use of by a foreign entity of non-public methods to force someone in Canada to do something or to not do something. So at a certain level, basically, it's using diplomacy combined with intimidation. Right, so secrecy and intimidation, that's very interesting because I thought it was unfortunate to not be able to define a concept. Yes, go ahead. In listening to everyone, I would say one difficulty is the application. When I was reading the bill, I thought it wouldn't be unreasonable to ask the Minister of Public Safety to do an annual report or review, because there will be the CSIS on one hand, the Commissioner on another, the Director of Elections. But perhaps the Public Safety Minister could bring this all together for the benefit of the public and Parliament and report on that. Well, that's an interesting idea because normally CSIS and Parliament or CSIS and other agencies don't necessarily speak to each other. So there's supposed to be a 5-year review. But if I look at the Security of Information Act, I see that there hasn't been reviews that were provided for. So the government doesn't necessarily seem to be in the habit of reviewing its legislation every 5 years. Is there something that could be done? Well, one could say that the legislation ceases to exist if there isn't a 5-year review. Now, it's quite a severe approach, but it would be something like that. If the review has not happened, there should be, in fact, there should be provisions that no longer exist. Well, that's an interesting idea. Thank you very much.
Going on to Mr. McGregor. 2 minutes and a half, please.
Thanks, Mr. Chair. Ms. Fung, I'd like to continue with you. There have been a lot of comments made about the urgency to get this act in place quickly, given the seriousness of the issue. The consequential amendments to both the Security of Information Act and the Canada Evidence Act, they all say that they come into force on the 60th day after which this act receives royal assent. So that's a pretty tight timeline. It's Part 4, though, the new registry, that is really up to a day to be fixed by an order by the Governor and Council. And I think, so we have the parts that are going to deal with the more clandestine nature of foreign interference coming into place relatively quickly. We'll see how well federal agencies can make use of those new tools. But the new registry is very much up in the air. You had made mention in your opening comment about, I guess, having, was it some kind of a commission to oversee how this act comes into force? Do you want that set up as a parallel to cabinet, or I just want to understand the mechanics of how you'd like to see this work?
Yeah, actually, this suggestion is based on, the Australian model. So they have set up an independent commission to, oversee and monitor, the implementation of all the foreign interference related measures. I think in Canada, we do require such an independent commission to be set up because, and it should be totally independent of the government so as to maintain that neutrality and fairness in managing all the foreign interference cases. Yeah.
Thank you. And then you had also talked about having a review, I guess, fairly soon after the next federal election, just to see how these new legislative provisions acted in practice, and then having the formal review 5 years thereafter. Yeah, so that's what you wanted to see us focus on?
Yeah.
Okay. Okay, I'd like to just end by thanking you all. Really appreciate your testimony today. Thank you.
Thank you, Mr. McGregor, and thank you to all the witnesses for joining us today. Your testimony is most helpful to our work, and thank you also for making yourself available on such short notice. As you know, we're under very short timelines to pass this bill, and of course you understand the importance of doing so. So thank you all. We will now suspend and bring in the next panel. Thank you all. I call this meeting back to order. So I'd like to welcome our witnesses for the second hour. We have appearing today as an individual, we have Mr. Christian Lupret, Professor, Royal Military College of Canada, Ms. Emmanuelle Réau, attorney, and from the Business Council of Canada, Trevor Neumann, Vice President, Policy and Legal Counsel. And if I managed to get your names close, I'll congratulate myself. If I didn't, I apologize. So I would like to thank you all for your participation today in our meeting and your flexibility in being able to appear so quickly. So I would now invite Mr. Leprec to make an opening statement of up to 5 minutes. Please go ahead, sir.
Monsieur le Président, merci.
Thank you, Chair. Thank you, committee members.
Expertise on matters of national security and intelligence across allied and partner democracies, including my book, Intelligence as Democratic Statecraft, Accountability and Governance across the Five Eyes Security Community. Gathering Storm est le titre du volume.
Gathering Storm is the title of Volume 1 of Winston Churchill's 5-volume history of World War II. That title is apt to recall that once again the fall and dissolution of the Soviet Union introduced a sense that liberal democracy was ascendant and spreading. More than 30 years later, around the globe, democracy and democracies have been in retreat. They're coming under growing duress from confident authoritarian regimes and other enemies of democracy who use hybrid warfare activities that leverage gray zone tactics to undermine democratic institutions, political processes, economic prosperity, and social harmony.
Here in Canada, recent reports by INSERA and the NSI Corp expose vast and significant vulnerabilities across a broad scale, including the systemic infiltration of Canada's political, economic, and social institutions by adversarial actors who are prepared to go as far as alleged treasonous behavior. These reportedly include some of your own colleagues. It could hardly be more ironic that two review entities created by this government to improve the accountability of agencies effectively end up holding the government to account for having been naive and negligent on intelligence and national security. Make no mistake, the now well and widely documented activities by hostile actors pose an existential threat to Canada's security, prosperity, and democratic way of life. For too long, this government and its predecessors have taken democracy for granted. Instead, democracy needs to be defended. The fragility of Canadian democracy is on full display, yet the bill shows neither courage nor ambition. It amounts to a minimalist approach. It represents the absolute minimum the government would have to do anyway, but only once its hand was forced. The bill does not update the national security threats to Canada in Section 2 of the CSIS Act, which dates from 1984. It fails to remove Section 16, which is proving a growing impediment to CSIS to fulfill its mandate. It introduces a minimalist 5-year review of the CSIS Act only, instead of the entire security and intelligence framework and posture, as Australia does. Although it amends the Security of Information Act, notably removing the threshold of harms to Canadian interests, it forgoes other important updates, such as the harms provision in Section 3. Why the bill would not grant the minister the ability to designate a list of states and actors of concern as part of the Foreign Influence Transparency Registry, as the UK does, is beyond me. Unless the aim is to avoid ensnarling any one political party's sycophants, lawyers, and accountants that make a pretty good living off their hostile state patrons. This bill does not give Fintrac explicit enforcement powers to track and seize assets and transactions that are being used to enable foreign interference. There are no amendments to the CBSA Act to deem inadmissible persons suspected of engaging in foreign interference in Canada or another allied country.
and the bill fails to reform the RCMP with the aim of making it more targeted and effective at meeting its federal mandates. Cette semaine, pendant la période des questions,
This week, during question period, the Prime Minister claimed that his government would do whatever it takes to keep Canadians safe.
Could you stay back from the microphone a bit? It's a problem for the interpreters.
Pourtant, dernière phrase.
Yet, and this is my last sentence, Chair, this bill barely sets minimum thresholds to protect Canadian democracy and make its defense more proactive, robust, and resilient against highly persistent and adversaries. Thank you.
Thank you, sir. I will now invite Ms. Rayo to make an opening statement of up to 5 minutes. Please go ahead.
Merci, Monsieur le Président.
Thank you, Chair. First, I'd like to thank the committee for giving me the opportunity to speak to you today. I've been a lawyer for 10 years, and I practice exclusively in criminal cases, the defense of criminal cases. So that is part of my daily life. And some of the Evidence Act as well is part of my daily life. So I'm going to speak mostly to this, but I'm also going to speak about the security of information regarding some sections that you, and as well as the sections you'd like to add to the criminal code. First of all, regarding the criminal code, more specifically sabotage. That's section 52 under the criminal code. I have several changes to suggest. Some of what the committee is doing is praiseworthy, but some of the changes are alarming. Sabotage does not exist as a crime in the UK. In the United States, it's much more restrictive under their federal laws. And in New Zealand, sabotage is much more restricted as an offense than what the committee would like it to be here. Now, in terms of Section 52(1), in the previous version, it's a prohibited offense causing harm. Now, this is a section that is difficult to understand in its current form. So the amendment is a good idea, and it's appreciated. It will be much clearer in the way you are stating it. The exception under subsection 5 is also an improvement on the current version because you're adding an exception for regarding certain groups. However, I think it's too restrictive. 52.1 and 52.2 are much more problematic in my view. If you look at 52.1 in the criminal code and the creation of a new offense in terms of critical infrastructure, I'd like to say first that it's much too broad. And 52.1c would compromise the health and safety of a part or all of the population. Well, 2 individuals could be considered as being part of the population, so you don't necessarily have to be a huge number. It also says that would compromise the security or the safety. That's also very broad. I'm saying this because the broader sections are, the less they might pass the test before the courts, the less likely they would. Furthermore, critical infrastructure. In Section 2, you provide a definition of critical infrastructure. However, private companies are also included. So if I look at subsection 2 of 52.1, you could have a private company like TeleCubeSoft or other video companies could be involved because if you push it far enough, these are technology companies. So you're not simply focusing on state companies or companies that are regulated in provinces or the federal government. You're just including private companies, so that's problematic. Now, when it comes to economic welfare that you're adding, that's also much too broad. It's not restrictive enough. And I don't see it defined either in the criminal code. Furthermore, you're adding a safeguard in subsection 5 regarding demonstrations. It's not restrictive enough, in my view. When you say that there is an intention to provoke under subsections, well, it's not consistent with New Zealand's legislation, where they're simply speaking to demonstrations. So I think it can become too speculative, too broad. What I would also note under these sections are the harms. Harms exist already. And you're talking about all kinds of harms here. So there would be, for example, a prison sentence of 10 years. You want to make it higher. In 52.2, there are also problems with the definition of devices. So it's not simply devices that are computers. It can be much more. So it can be broader. It could involve arms, weapons, and that could be a problem as well in terms of the courts. I'll go very quickly now. 52.3, in terms of the Attorney General's consent, if the committee wants the Government of Canada to be able to manage these sections, then you're missing some wording in these sections.
I now invite Mr. Neumann to make an opening statement of up to 5 minutes, please.
Mr. Chair, committee members, thank you for the invitation to take part in your study of Bill C-70. As an organization representing Canada's most innovative and successful businesses, I will restrict my comments today to the portion of the bill that has the most direct relevance to the Canadian private sector. That is Clause 34.3, which seeks to amend the Canadian Security Intelligence Service Act to enable CSIS to disclose threat intelligence to stakeholders outside the Government of Canada for the express purpose of increasing their awareness and resiliency against foreign interference. However, before commenting on this clause, I want to make clear that Canada's business community is broadly supportive of Bill C-70, from the establishment of a foreign influence transparency regime to the creation of updated offenses for attacks directed against essential infrastructure. This urgently needed bill will help protect Canadians' lives and livelihoods by providing our governments with the tools that they need to better protect our economy and our society. I'll start my substantive remarks by noting that while the current discussion in Canada surrounding foreign interference has been rightly focused on the integrity of our democratic processes and the safety and security of targeted ethnic and cultural groups, it is important for us all to acknowledge that state actors actively target all aspects of Canadian society to advance their strategic interests. This includes the Canadian economy. Indeed, in an era of growing geopolitical rivalry, in which supply chains, infrastructure networks, and technological innovation increasingly determine strategic advantage, Canadian businesses are often the primary target of our adversaries. This should concern all Canadians. Economic security threats are not abstract, nor do they exist in a vacuum. These threats target the critical infrastructure needed to heat and power our homes. They target the supply chains that provide our families with low-cost medicine and food, and they target the intellectual property that creates good jobs and pays our bills. In short, these threats put Canadians' very safety, security, and prosperity at risk. Now, to be sure, Canadian businesses and governments invest billions each year to keep Canadians safe from these and related economic attacks. However, if we want to be truly effective in protecting our way of life, then we must replace our independent efforts with collective action. Key to building this partnership is the sharing of threat intelligence. Unlike the domestic security agencies of Canada's Five Eyes partners, such as the United States FBI or the United Kingdom's MI5, who possess modern authorities allowing them to share detailed threat intelligence with their respective business communities, CSIS is presently prohibited from sharing all but the most generalized information with the Canadian private sector. This represents a significant gap in Canada's defenses. despite CSIS having both the knowledge and expertise to help companies withstand growing threats. CSIS's outdated legislation means that Canadian businesses are left fending for themselves. It is for this reason that the Business Council strongly supports Clause 34.3. With new threat sharing authorities, CSIS can communicate more specific and tangible information with Canadian companies. This would give business leaders a clear understanding of the growing threat, as well as the protective measures that could be taken to better safeguard their employees, their customers, as well as the communities in which they operate in. The use of these new authorities could also benefit the Government of Canada by helping CSIS build greater trust with the Canadian private sector. This would encourage Canadian business leaders to share more with Ottawa about the threat they're seeing on the ground, which would better inform government policy, as well as improve CSIS's ability to respond to emerging threats. Of course, the granting of any new authorities must be consistent with the values that we share in our democratic society, including respect for individuals' rights and freedoms. On this front, we are very pleased to see that the Government of Canada has incorporated rigorous standards and safeguards into Clause 34.3, such as to ensure that individual disclosures protect Canadians' privacy interests. Before concluding, I want to stress the need for urgency. The Business Council of Canada agrees with many lawmakers that the protections contained within Bill C-70 must be put in place before the next general election. The preservation of our democratic system is of utmost importance. However, I will add that when it comes to strengthening the resiliency of our economy, Canada is falling well behind our allies. This not only exposes everyday Canadians to unnecessary risks, but by failing to move in lockstep with our closest allies, we risk being perceived as a weak link. This could jeopardize our country's relationship with its closest allies, especially the United States, at a pivotal moment when the global order is being reshaped and partnerships matter most. I'll conclude by noting that C-70 is just one of many economic security reforms that must be urgently undertaken to protect Canadians. As a priority, the Business Council urges that the Government of Canada complement Clause 34.3 with a formal threat exchange to securely receive and disseminate CSIS's threat intelligence broadly across the Canadian economy. This and nearly 40 other much-needed reforms are included in the Business Council's recent report, Economic Security is National Security. That report is available on our website. Thank you for the opportunity to speak. I look forward to your questions.
Thank you, sir. So we're going to start our questions now with Mr. Shipley. 6 minutes, please.
Thank you, Chair, and thank you to all the witnesses for being here this evening. I was about to say today, but really is this evening. I'd like to start with Mr. Lupret, if I could, please. Mr. Lupret, you were very, and I hope I'm saying your name close. All right, I got a thumbs up, so I'm close. You were very passionate in your opening remarks, and I was listening quite intently, and you mentioned the very beginning of it about systemic infiltration, and you mentioned the words treasonous behavior. Could you expand on where all you think this systemic infiltration is?
Look, it's not what I think in terms of systemic infiltration. We have plenty of evidence at the municipal level in terms of infiltration. We have ample evidence in terms of research security within our universities. We have evidence at the provincial level of government. And we have evidence, including charges laid within private and public sector institutions in this country, including, of course, the government just this past week forcing 2 entities in Vancouver engaged effectively what it appears to be the illicit transfer of dual-use anti-drone technology to a hostile actor. So I don't know. I can send you a long list, but the public record on this is extensive.
Well, I appreciate that. That's a good start, and that's a little disheartening to hear, but at least we're doing something to try and correct it a little bit now. I'd like to stick with you, sir, if I could, because we've heard different perspectives on the in favor and opposed to Bill C-70's country agnostic approach to the foreign registry list. I think the beginning you mentioned you definitely see a benefit to listing countries. Expand on that, why you see that being a benefit. And you mentioned persons too.
Yeah, I figure this is probably going to be one of the more critical decisions and one of the more controversial decisions. And I can see both sides, including Director Fadden's sort of case for not. I think giving the minister the option. So look, much of what this legislation will ultimately do, rather than us sort of prosecuting people, is about drawing red lines. It's establishing clearly what sort of behavior is and is not acceptable in this country. This is what much of criminal code, for instance, also does, right? Just laying out the rules of the road. And the problem that, for instance, universities have when it came to research security, where the government made a similar choice, where it listed only public sector entities, but not private sector entities, all of whom have Communist Party structures within them that pose the exact same threat that public sector entities engaged in intelligence and defense do, is that for universities, private sector actors, it doesn't provide a reference point based on which they can then engage in higher scrutiny. And so without government providing that reference point, it'll become relatively easy to accuse universities of randomly, for instance, scapegoating or whatnot. And so I think more direction from government is required for those players that do not have the classified access that federal government entities do, including on the research security side, for instance, where I chair the Ontario Research Fund Advisory Board, and where we know there's significant challenges around what is being funded.
I'd like to move to Mr. Neiman. Mr. Neiman, in a letter to the previous Minister of Public Safety, the Business Council of Canada stated that you wanted to see, and I'll quote this, amendments to the Canadian Security Intelligence Service Act to allow CSIS to proactively share threat intelligence with employers where it is in the public interest and subject to all necessary safeguards and oversights. Can you speak to this new information sharing powers in C70 and if that's meeting your requirements?
Thank you for the question, Chair. So as I mentioned in my opening remarks, CSIS is presently prohibited by its governing statute from sharing all but the most generalized information with the business community. And this is because, for lack of a better word, the federal government is the CSIS's exclusive client. Therefore, the private sector can't get access to information, academic institutions can't get access to information, nor municipalities or indigenous governments. The only exception to this general rule is once a national security threat materializes into an imminent national security event. And at that point, CSIS, if it can satisfy some very stringent legal requirements, it can use its threat reduction mandate to alert a specific company about a specific threat. This means of sharing information, it's very much a legislative workaround. These threat reduction powers were not designed for information sharing, and so this process is deeply flawed. The main reason it's flawed is because, as I mentioned, there's a very strict legal requirement that must be met before information can be shared. That means that these powers are rarely used. Second of all, the regime is reactive in nature. Threat information can only be disclosed after a material and an immediate threat has emerged. At that point, that information provides very little utility for a business, as their options to mediate or to mitigate the threat is very few. Moreover, that, as I mentioned, that the disclosure can only be made to a specific business that has been targeted. So if the goal is to strengthen the overall resiliency of the Canadian economy, well, that the current set of tools are inadequate, and that's why the Business Council has been very supportive of the adoption of Clause 34.3, which allows CSIS to proactively share threat intelligence with a broader set of stakeholders, including the business community. You mentioned in there that the Business Council, as a part of advocating for these changes, we've been very clear from the start that any new amendments must be reflective of the values that we share in our society, including protection of individuals' rights and freedoms. And so we're very pleased to see, and I can get into this more maybe in another question, but there's a number of checks and balances to protect individuals' privacy, corporations' privacy, as well as there's accountability mechanisms there as well. For instance, if there's a disclosure of personal information or corporate information that is otherwise prohibited, that information needs to be shared with NSERA. And there also needs to be ministerial authority granted, and the minister in that case must be of the view that the disclosure is essential in the public interest, and that the benefit of the disclosure to Canada's national security clearly outweighs the privacy implications.
Thank you, Mr. Shipley. We go now to Mr. McDonald for 6 minutes, please.
Being here, Mr. Neiman, I'm going to continue on with following up on Mr. Shipley. It's Business Council of Canada. About 2 weeks ago, I had in the Insurance Bureau of Canada and discussed the increasing risk that small and medium enterprises are facing, possibly through cyber attacks, which can lead to foreign interference based on whatever content that they're in possession of. And it was interesting because they were asking us, relevant to how do they deal with it? So how are companies dealing with something like this now? Are they buying insurance policies on cyber attacks, and which will lead likely to foreign interference if, for example, that they hold certain information that could be very essential to them, to an individual or a community group or something?
Mr. Chair, thank you for the question. The Business Council, we represent approximately 170 of Canada's largest, most successful businesses, so I can't speak to the specifics of the challenges facing small and medium-sized businesses. But what I can say is that small and medium-sized businesses, they're very much a part of the supply chains of large businesses, and large businesses are quite concerned about their security posture, small businesses, because that can often be an indirect route to attack large businesses. And so there needs to be much more done in this space in terms of government support, and Bill C-26 is one way to help in that regard. The private sector itself is also willing to step up and do more. For instance, our members are very much committed to working with their supply chains to build up their baseline resiliency, including through education, capacity building, and relationship brokering, including working jointly with Canada's security and intelligence community, such as agencies like CSIS, CSE, and the RCMP.
And this committee just did a review of Bill C-26, and during that testimony, we heard that there was about 5.2 million cyber attacks in 4 months in 2023, from September to December, if I think of them correct. 62% of which were targeted critical infrastructure. And in our testimony of our last meeting, Michelle Juneau stated that 86% of our national infrastructure is either owned or operated by the private sector. So it's going to become a very serious issue, or it already is a very serious issue. We may not even be aware of what's transpiring underneath. But what's the best way to go about this, to delivering that message and ensuring that there's safeguards in place within this bill? Or you talked a little bit about, you had 40 items that you guys did a report on. Can you maybe talk a little bit about, give us a couple of examples on that and relevance?
So the Business Council did put out a recent report last September setting out pretty comprehensive set of reforms that we believe the government of Canada should adopt to address the most glaring gaps in Canada's economic security posture. We were very happy to see that a number of them were incorporated in this bill, particularly the Clause 34, allowing for increased information sharing. And as I mentioned at the beginning of my remarks, that we've also supported the Foreign Influence Transparency Registry, as well as the new sabotage offenses as it relates to the protection of essential infrastructure. At the same time, I mentioned in my opening remarks that we think that this bill should move forward on an expedited basis, and so we wouldn't want to make significant changes to the bill that would slow down that process. However, we would hope that the government would try to bring in some of the additional changes that we suggested. But you mentioned critical infrastructure, and I just want to provide a short commentary on that the Business Council is very supportive of the amendments to the sabotage provisions. We note that the current provisions in the criminal code date from 1951, and they have not been updated since then. Obviously, the threat environment has changed drastically since then. We see more and more that our adversaries have an increased intent and willingness to target and undermine our critical infrastructure. That those are the systems that allow Canadians to heat and power their homes, communicate with their loved ones across this vast nation, as well as to get their goods to and from international markets. And the disruption to those systems would be absolutely devastating to Canadian society. I don't think I exaggerate much when I say that a substantial disruption to our essential infrastructure could put millions of Canadians' lives, their security and prosperity at risk. So we think that the amendments are a good step forward. And we're also very happy to see that the government has included some safeguards in there, including to make exceptions for work stoppages related to labor disputes, as well as exceptions for individuals that are legitimately engaged in advocacy, dissent, and protest, as well as the requirement for before proceeding to be brought for the Attorney General to provide consent. We think that those protections in there provides the right balance between protecting Canada's economic and national security, while at the same time making sure that these provisions are respectful to individual Canadians' rights and freedoms.
Do we have much time left, Mr. Chair?
28 seconds.
20 seconds?
28.
28. Mr. Poe, if I didn't ask you a question, our good friend Mr. Desiree would be upset with me when I get returned to Prince Edward Island. So I'm going to ask you quickly. You talked a little bit about, and you didn't use this word, but contextualization of maybe the agnostic list. You were somewhat against that in your preamble, and can you quickly just give me before the chair cuts us off, your main reason for that?
I think entities need a clear signal of the sort of, so if you're a university, you're a private sector company. So to be fair, you now need to, and this Australia ran into this problem where all actors, foreign actors, need to be treated equally. So if you're a foreign visitor to, for instance, a university from Germany, or you're a foreign visitor from, I don't know, some hostile state, the university cannot treat the risk assessment differently. So it means the very scarce resources you have, you cannot deploy in a targeted fashion. So just giving the minister the option. The other advantage is it allows the government to negotiate, because if it gets indirect threats from a hostile state actor, the government can now sort of indirectly signal that, well, if you're going to treat us like that, we might end up listing your particular country. So maybe two can play at this game.
Thank you. C'est maintenant Monsieur Villemur.
Mr. Villemur, you now have the floor. 6 minutes. Thank you very much, Chair, and thank you to all our witnesses, Mr. Lehman, Mr. Luprecht, and Ms. Rowe. So I'd like to talk about something you said. You said earlier on that it's too restrictive, or there's one word too many, too few words. I'd like you to be able to expand a little bit. Well, if I take 52.4, for example, on the consent of the Attorney General, there cannot be a proceeding for an offense under subsection 52.1, 52.1, or 52.2 without the Attorney General's consent. So the Attorney General is defined for the federal government, but what about the provinces? If the government of Ottawa wants to have discretion, then it has to say Attorney General of Canada. That would allow the federal government to have this kind of discretion over some sections in the criminal code. So it would also work better internationally. There's also an exception under subsection 5. That is to say that protests, or if something happens during a protest or advocacy, but there's no intention to cause any of the harms, well, that's very broad. And the same problem occurs. I haven't seen this kind of section in New Zealand. I only saw it in this bill. So there would be problems in this being too broad a section. Well, what about amendments to the CSIS Act? On protection of information, you mean, or rather security of information? Because I'm not familiar with all the terms that have been used, but there are some sections that are in the criminal code, and so I restricted myself to those sections. So there's 20.4, where there is mention of influencing a political process directed by a foreign entity. It's a very general section. Yes, the foreign entity is defined. However, I can see how there would be examples. I'm sure the committee had certain ideas in mind when it proposed these amendments. However, when you word it like this, when you talk about groups of influence, well, that could cover many groups. And I would say, once again, it's too broad, especially when you're speaking about criminal offenses. So perhaps it actually could be challenged. Mr. Lebrecht, you were very passionate, and basically it boiled down to this is the minimum. You said many things, but if you were going to have a list of priorities of what was lacking, what would you say those are? Well, I would say generally that at the federal level, there's a problem with information sharings in an efficient way, effective way, and in a timely way with those stakeholders involved. And we've seen this raised before in recent reports of committees. For example, those dealing with accountability.
That FinTrack has trouble sharing the right information. We know this from CSIS. We know we have it within agencies and between agencies. And so I think the way the bill enables the ability to share information within government, with external stakeholders, and we have some very good models. The Canadian Cyber Threat Exchange, for instance, the Canadian Center for Cybersecurity, where I think there's probably significant synergies with CSIS in terms of sharing threat actor information. So some entities we've cracked it precisely because the government has enabled the information sharing provisions. And I think we're just too restrictive, on a total restrictive.
So you said there's a lack of courage and ambition here. That's quite striking. Now, the bill also contains a provision requiring a 5-year review. And there are many pieces of legislation that haven't managed to be reviewed every 5 years. A previous witness suggested that perhaps the legislation actually should cease to exist if it's not reviewed after 5 years. Now, that's rather strong, but can you think of pieces of legislation that has been reviewed after 5 years? Well, in other countries? Well, in Australia, there has to be this overview that's done of the architecture of national security every 5 years. And there's a fair bit of flexibility for the individual who is responsible for that. The report is quite long, but usually there's a focus on one aspect in particular, and an attempt to suggest improvements. So we're talking about pieces of legislation that aren't necessarily always visible to the public or to MPs because they're very, very complex. There can still be very significant consequences in terms of the protection of civilians and human rights. And given that the security environment is changing very quickly, and there are definitions in our legislation dating back decades, we need a tool that would allow members of Parliament to be able to act in a more timely and efficient manner.
We go now to Mr. McGregor for 6 minutes.
Thank you very much, Mr. Chair. Thank you to all three of you for joining us today. Professor Lupprecht, I want to revisit the issue of Part 4 being country agnostic, because I just wanted to present to you like a hypothetical situation. Of course, the government of the day is guided by different political leanings, and it may view certain countries in different lights from its competitors in the House of Commons. I'm just wondering of a situation like in terms of listing a country, could there not be the potential of the government of the day's trade interests colliding with the country's national security interests, right? It's a very political decision to list a country. Does that not come with some pitfalls because that's essentially a political decision? There could be other things guiding a government's decision rather than purely the national security interests of Canada. Is that not a danger?
And we had exactly that situation very recently in terms of the reimposition of certain visa requirements on Mexican nationals to Canada, where there was a vigorous internal debate on precisely this sort of trade-off. And ultimately, this gives, if you want, the Minister of Foreign Affairs a stake on both sides, because the Minister of Foreign Affairs ultimately can make the trade argument, but the Minister of Foreign Affairs would also have the opportunity to list a country. And I think the listing regime is important because we've been very poor in the last 20 years of anticipating the evolution of the international security environment. And so in a case of a rapid degradation of the international security environment, where the government feels it might need to take fairly aggressive, rapid measures to protect Canadians and Canadian interests and Canadian institutions, this, I think, is an important tool that we will, not may, we will regret within your and my lifetime if it is not inserted into the bill.
In the interest of transparency, would we not also have an interest to know how maybe some of our closest friends and allies are influencing our political processes?
Yes, but they don't need to resort to covert, clandestine, coercive.
But that wouldn't be covered by a registry. The clandestine wouldn't be covered by the registry.
So our closest allies have plenty of legal mechanisms. I think for me, the primary purpose of the registry is to lower the evidentiary threshold for investigations. Because in many cases, it is very difficult for security and criminal intelligence to reach the current threshold as defined in law in Canada. So with the registry, you are now giving the agencies a much lower threshold for the purpose of investigation. And that, I think, is the primary purpose.
Okay, thank you for that. I also want to recognize that you, from your comments, you see Bill C-70 as a bare minimum, and you did mention other statutes that you wish could have been acted. We're limited by what's before us. We can't go beyond the scope of the bill. But in the amendments to the CSIS Act, you did make mention of the fact that Section 16, a lot more could have been done with it. However, with what the government is proposing here in its amendment to Section 16, are you happy with that as an addition? Do you see any kind of improvements that we can make as a committee?
I think what I was hoping to signal is that there's nothing in this bill that you can really reasonably strip out of the bill, right? This is the minimum threshold. This is that's the primary signal that I was hoping to send, and I appreciate that the government did have the guts to tackle Section 16 because that is inherently a long-standing controversy, and so just actually going there shows that there's actually some willingness to engage constructively on some key matters that might subsequently come up in other bills for further amendment.
Thank you. Ms. Rayola, I'd like to turn to you, your expertise in criminal law. Of course, there are some significant amendments to the Security of Information Act with significant offenses and punishment. I think pretty much all of them involving life imprisonment. I know other offenses involving life imprisonment can be things like treason, mutiny, and things like that. Do you feel that the offenses listed in these new amendments to the SOIA, do you think the punishments are in line with how, do the punishments match how serious the offenses are, in your opinion?
Well, I'm a defense lawyer first. So I take a humanist approach to my clients, and that's what guides me on a daily basis. But traditionally, life sentences have to do with violence or a risk to life, for example, or the risk to someone's personal integrity or terrorism. And when I read this bill, life, I think, is out of proportion with respect to the offenses that I see. There's 14 years in the criminal code, which is, I would say, fairly common for similar offenses.
Thank you.
Thank you, Ms. McGregor. So we'll start our second round now, and we will end this round with Mr. McGregor. And we will start our second round with Mr. Lloyd for 5 minutes, please. Thank you.
Thank you, Mr. Chair, and thank you to the witnesses. It's good to be back at committee. My wife and I welcomed our
third child 3 weeks ago, so I've been taking a little bit of time. Thank you. Thanks to my colleagues for supporting me during that time. I'm going to talk about an issue that I don't think gets talked about enough. It's not really controversial, but in Section 31 of the bill, we have the 5-year mandatory parliamentary review. And in this legislation, differently from the NSICOP Act, there's also a report that needs to be given to Parliament within 1 year of that review. My concern is that we're currently almost 7 years, or we're 2 years overdue for the report on the NSICOP Act. And I'm concerned that if this legislation goes forward as is, that a future parliament, and it might not be until 2 parliaments from now, given that there's a 4-year mandate if there's a majority government, it might not be until 2 parliaments from now that this critical legislation gets reviewed. And so, Dr. Luprecht, I was wondering if you had any suggestions or recommendations on perhaps should we shorten that review period from 5 years, and should we put additional language in there to ensure that this review takes precedence at committee rather than just being shuttled off whenever another piece of legislation or an important issue comes up, that just like the NSICOP Act review has been delayed. Thank you.
We live in a democracy, and it's ultimately up to the government of the day and our elected representatives to decide what the priorities are, how they're going to tackle them, and I think the Prime Minister has made that very clear also with intelligence and national security. There are, of course, other examples. The Proceeds of Crime, Money Laundering, Terrorism Financing Act, where the review is long overdue. I think, nonetheless, as a prof, my students, the first thing they always want to do is change legislation. I always tell them, changing legislation is probably the single hardest thing you could possibly think of. Think of a tax incentive, a policy, a regulation, whatever. Don't try to change legislation because you might spend a decade. Or you have to look for a political opportune moment to bring legislation such as this or C-51 or so. But nonetheless, it keeps the attention on the matter, where otherwise I think it would just drop off the radar and nobody will pay attention until we run into some sort of crisis. And if we think that the first and foremost obligation of the state is the safety and security of the citizens and of its political, economic, and societal institutions, then we need to have a mechanism to at least try to keep our eyes on the ball. And that's what I think these reviews do.
Do you feel that the mechanism that currently exists in this bill, which is similar to other mechanisms we've seen, 5-year review, the language was slightly different. The language in this bill says must, but the language in previous legislation says that the committee is to. And I'm not sure that really gives any more clarity on whether or not committees will be mandated. It will be up to, as you said, whether or not the democratically elected officials at the time or the government at the time places a high priority on it. But clearly this is a high priority, and it's been something that's been neglected for far too long in this country. Would you recommend expediting those reviews to under 5 years? And also, would you recommend language that made it stronger and put the emphasis that this needs to take priority maybe at the same level as legislation, which usually takes priority at committees?
So when the current government came to power, I think it had 85 reviews on the go at the same time. My concern is that we are too specific with the reviews, and it is generating too many reviews. And we would probably be better off with either a national security and intelligence review or perhaps within the remit of this committee, a 5-year review on countering foreign interference, the mechanisms at our disposal, what did we do 5 years ago, what's working, what's not working, what could work better, rather than trying to limit our swim lane so precisely to one institution and one agency and one particular act.
Thank you. And, some discussion that was on with the last panel was discussing whether this needs to be an independent officer of Parliament. Did you have any feedback on what's the pros and cons, or what would be your recommendation on that matter?
I've written on this publicly. I'm not a big fan of the proliferation of independent officers of Parliament, in part because I think reporting to the executive actually gets us, I think, more timely, more efficient, and in many cases more effective action. And I have a lot of faith in whatever executive is empowered to action. So I don't think an independent officer of Parliament will help with transparency. I do not believe that an independent officer of Parliament will help get things done and will help to get it done faster, better, or sort of more efficiently. So I think the bureaucrats are very well intentioned, or an independent outside judge, or some combination thereof, as Australia has done in the past with people who understand the system. I'm not sure you'll get something better out of an independent officer of parliament, but I'm married, so I know I'm wrong all the time. So,
Thank you, Mr. Lloyd. We go now to Ms. Zaid. Ms. Zaid, go ahead, please. 5 minutes.
Thank you, Chair. Thanks to all the witnesses. My first question is for Madame Roulette. If I don't pronounce your name, please, apologies for that. This legislation takes a country-agnostic approach. Instead of creating a list of the so-called problematic countries it would apply to. So a list-based approach would be hard to update with changing and emerging threats, be open to political influence and considerations, and potentially stigmatize innocent members of the diaspora communities. So can you outline the risks of a list-based approach and why it is important to not unfairly stigmatize diaspora communities who are often at the greatest risk of the foreign interference and the threats?
Well, to my knowledge, the list that you're mentioning has no impact in terms of the Criminal Code or the Evidence Act. And that would make sense because the Criminal Code focuses on offenses in Canada and individuals, so not entities. You know, you can't, under the Criminal Code, you can't prosecute an entity or a state. So, but I'm sorry for in terms of the rest, that's rather outside my area.
Would you like to comment on that?
So you heard the witnesses before us. The concern that I hear from my friends and colleagues and in public isn't so much about stigmatization. It is about foreign repression in their lives by hostile state actors. And I have written publicly about my concern that all this talk about stigmatization risks playing into the narrative that precisely our hostile state actors are using in order to impede our ability to pass precisely the legislation that will keep our diaspora communities not only safe from foreign repression, but will protect the freedom of expression in this country.
My next question is again for Madame Roulette. This legislation adds the word intimidation in Section 20 of the Security of Information Act, and I quote, "Every person commits an offense who, at the direction of, for the benefit, or in association with a foreign entity or a terrorist groups, induces or attempts to induce by intimidation, threat, or violence any person to do anything or cause anything to be done." End quote. I agree with the spirit here, but do you feel there needs to be clarity on just what constitutes intimidation in this context?
Certainly, threats and violence are defined in criminal law. Intimidation isn't. So Parliament needs to define it. If it doesn't, then you open the door to courts having to define it themselves. And eventually perhaps going as high as the Supreme Court. So yes, it would be preferable to define this concept clearly. That is to say what Parliament considers intimidation to be.
Thank you. My next question is for Mr. Neiman. Can you please explain how the threat sharing with UK companies has worked out, and are there any lessons to be learned from that?
Mr. Chair, thank you for the question. I'm not intimately familiar with how UK operationalizes the threat intelligence. However, at the highest level, I do understand that amongst the Five Eyes nations, Canada is an outlier in terms of the lack of authorities that our domestic security agency has to share threat intelligence with the business community. We just spent a week in the United Kingdom last month where we met with the UK's domestic security agency, MI5, and they have a special body that is designed purely for the purpose of collaboration with the private sector. And they had told us quite specifically that they have the authorities that CSIS is now seeking through Clause 34. And they tell us that those authorities are working effectively, and it's allowed them to build very robust partnerships that has been starting to build increased resiliency across the economy. We've also had an opportunity to recently travel to Washington, D.C. to meet with the Office of the Private Sector, the Federal Bureau of Investigation, and they also have similar authorities. And there's the model that we looked at in the United States that has worked quite effectively is something called the Domestic Security Alliance Council, which is a joint partnership between 700 strategically important U.S. companies, the Department of Homeland Security, and the FBI. And through two-way exchange of information between the United States government and the U.S. corporations, they're able to advance the United States mission of protecting that country's national and economic security, while at the same time helping U.S. corporations better protect their employees, their customers, and the communities that they operate. By participating in this organization, both the public and private sector gain access to senior leaders within those two sectors. The private sector gains tailored access to threat intelligence specific to their sector, and then the public and private sectors also gain access to a very large and robust network of senior security executives who can work together jointly to solve security issues, to share best practices. And we believe that Canada is really well positioned, CSIS in particular, Department of Public Safety, and the business community, to establish a similar body to DSAC to operationalize the authorities contained within Clause 34. So if we're looking for examples to operationalize what's contemplated in the legislation, I think the FBI and the DHS's Domestic Security Alliance Council would be a model that we should look for.
Madam Said, there's a competitive issue here, right, in terms of prosperity. Because why would you invest in Canada if you know you can get better threat intelligence in the United States, in the United Kingdom, or in Australia? So,
Thank you. Thank you. On y va maintenant, Monsieur.
Mr. Villemur, you have the floor for 2.5 minutes. Thank you, Chair. Ms. Rowe. My colleague made a comment here that made me think twice. Now, there was a great linguist who said to translate is to betray. So in Section 2, there's a reference to review by committees.
Within 1 year after the review is undertaken, must be undertaken. The must be undertaken.
So there's the must and is in French. They don't have the same force, do they? Do you see this kind of thing happening with translations in legislation? Well, in criminal law, oftentimes the versions aren't identical. There's often a difference between the French and English versions. Under the Charter, you have to use the version that is most favorable for the accused. Under the Canadian Charter I'm talking about. Well, in a bill like this one in C70, I have found 4 places like this where there are semantic differences between the French and English version. Should I be worried? Well, my simple answer would be yes. Well, then, I guess we'll have to take a closer look at this. I found 4. Is there anything you'd like to add to your testimony with my remaining seconds? Well, very quickly. I think I'm going to take my best shot at the answer to the question about intimidation. So in Section 483 of the Criminal Code, there are intimidation techniques that are described. Now, I don't know how that would apply to the question that I was asked earlier. And I'm going to say that in the Evidence Act, under 37.1, you're removing a section. It says that the accused must be found guilty, and it's only at the very end of the trial that a complaint can be laid. But there was in previous legislation, and there is elsewhere, an interim appeal. So, and I don't see that in this one. Well, I am worried about some of the things you're saying that aren't in here because we have to study this so quickly. So perhaps I'll just, I really just want to take 5 seconds to express my concern.
Mr. McGregor, please bring us home. 2 minutes and a half.
Thank you, Mr. Chair. Ms. Rayo, I want to talk to you about the criminal code amendments in this bill because in this bill, it largely follows the theme of combating foreign interference. And then you get to the section about the criminal code, and it just seems to have been thrown in there. And it doesn't seem to flow with the rest of the bill. I was trying to follow your remarks about the sections that you found problematic and too broad. But just in the time that I have left, where do you think we as a committee should focus if we're considering amendments to fix the problems that you addressed? Is it the sections where it's clarifying for greater certainty that, provides an out for someone that they're not committing an offense if they're involved in advocacy, protest, or dissent? Is that probably the best focus for us? I'd just like to hear your thoughts.
That's one of the best focus, yes, especially on the last 3 lines of that paragraph. 52.1 needs, in my humble opinion, to be looked over again by the committee. It's one with the adding section of the criminal code is one more problematic. It's too large. It doesn't focus, I think, on what the committee wants to focus on. And it would create a section where a lot of infraction would be thrown in, disregarding the purpose of that bill.
Okay.
So yes, and of course, section 52.3 also, if the committee wants the federal government to stay in control of those articles, 52.3 needs to be changed with adding
The
Attorney General of Canada. Yes,
Okay.
because otherwise you would lose all control.
Okay.
Province would get control of those.
Okay, appreciate that. I think I only have a few seconds left, so I'll just take that to thank all 3 of you for helping guide us through this study. Appreciate it.
Thank you, Mr. McGregor, and thank you to all of our witnesses for appearing today, and especially on short notice. It's most helpful, and we will, with that, we will adjourn. Thank you all. And to the committee, see you tomorrow morning, 8:15.